right ahead. Oh, I got enough time. All right, welcome everybody. This is an annual tradition that's developed over the last 3 or 4 years. Thanks to Judge Rufo. Judge Rufo contacted me, I think it must be 4 years ago now, and offering that we could set something like this up. And it's evolved a little bit over the years. And so what we're going to do today is go through a scenario of an interaction between young people and the police that results in charges, and the question about whether or not the evidence is going to be admissible. This will be a motion to suppress hearing. And it's going to be a bit abbreviated, as we were just talking about. A full-length one, particularly for the assistant district attorney, would involve a lot of background work that we can't do entirely in the time frame that we have. So we're going to grant Mr. Kelly a little leeway on that. But I very look forward to having. So let me introduce Judge Rufo, Attorney Rob Hoffman, Assistant District Attorney Matt Kelly. Judge Rufo is a Superior Court judge in Barnstable and Plymouth counties, serving both Barnstable and Plymouth counties. Rob Hoffman is Ms. Hoffman's husband, most notably. Most notably, which I only found out yesterday, so I'm still really, I think that's really cool. I didn't realize that. And Matt Kelly is a 1998 graduate of Harwich High School. Was president of his class, the very first class I taught here. The ones who broke me in and nearly broke me. But no, so thank you all very much. I'll let our Judge Rufo introduce what we're going to do today.
Thanks, John. Good morning, ladies and gentlemen of Harwich High School. First of all, a little disclaimer about why I called John Dixon about 4 years ago. First of all, I live in Harwich. I live right on South Street. Officer Davis knows exactly where I live, so I have to be very careful. So all the Harwich police know when I'm out there mowing my lawn or doing anything, they stop and make sure that I'm doing everything legally. And but I'm a resident of Harwich, have been permanently now for about 13 years, although we bought our house in 1984. But I've lived here for 13 years, and I do work in the court system, so I'm very interested in what's going on in my own community, as well as all of Barnstable County, because I am a Barnstable County Superior Court judge, and we have jurisdiction over all 15 townships that comprise our lovely Cape. So I came to vote at the community center about four and a half years ago. And these Harwich High School students in Mr. Dixon's class came up to me, and they came up to me, they used proper English, and started asking me questions about the Constitution. And he had put them up to this, of course, and they had some very interesting questions, and I was very impressed with the level of knowledge that they had. Of course, it's 7:15 in the morning that these kids are in the community center. And then I noticed a couple of days later an article in the Cape Cod Times about this venture, where as part of the Civil Liberties class, they were out asking people, and it was a good place to ask people because everybody comes to vote right here at the community center. So I followed up with him and said, I have this little program that I did up in Boston when I did live in Boston, in the school system, called Rights and Responsibilities, and we've modified it from there. So what are we talking about? Rights, meaning that we all have rights guaranteed under the Constitution, but we also have responsibilities that go along that correlate with those rights. So we're going to try to present a so-called challenge to constitutional rights in the form of a motion to suppress evidence. And this is a criminal scenario that we've developed just to get out some thought. And we'll do a little bit of role play. Officer Jeff Davis is going to be grilled by the defense attorney, Rob Hoffman. Matt Kelly and Rob both appear before me in real life in Superior Court. They're excellent attorneys. They've done very well in terms of their proficiency. Matt, of course, represents the prosecution. He represents the people. He's on the side of truth, justice, and the American way. He'll tell you that. And Rob, poor Rob, is the defense attorney, but also has the responsibility of protecting people from unlawful infringements on their constitutional rights. And this little scenario is what would come before me in the form of a court hearing where the officer is sworn to tell the truth and nothing but the truth by the clerk in the matter now hearing before the court. And then the DA has the burden to show through the evidence, and it's going to be a fact-finding mission, that the scenario or the facts are within the scope of the Constitution And Rob, of course, is going to try and pick that apart through cross-examination. And then based on legal precedent cases and the Constitution and my knowledge of the law, I'm supposed to make a decision that's, of course, reviewable by the appeals court or the Supreme Judicial Court as to whether or not I allow certain evidence in or not. Now, of course, if all the evidence is suppressed, meaning it's not admissible at trial, then Matt has to hang his head and he goes out the door crying some days because I don't let the evidence in, and that's his whole case. So the case goes south, meaning that the case is not able to be prosecuted, and it's a win, if you will, for the defense if, in fact, the motion to suppress is allowed. So Matt has the job of, if you will, defending the police action, and the police are in a really difficult spot because they're out there on the front lines, you know, administering what they believe is the law, and of course being concerned about public safety. And they do a remarkable job in terms of their knowledge of the law, what they can and can't do, because they learn through experience and their training, and they practically are lawyers themselves, although not legally trained. At least I don't think they're a lawyer.
No.
But they have enough knowledge of the law, and the DAs work with them all the time to develop this proficiency and understanding about what the length and breadth of their constitutional limitations are. So that's my quick introduction. All right?
Thank you very much.
ADA Kelly, do you have any witnesses today?
I do, Your Honor. Thank you. Good morning.
All right.
Commonwealth will call Officer Jeff Davis of the Harwich Police.
All right. He's been sworn.
Thank you. May I inquire?
You may.
Sir, in a loud, clear voice, can you please state your name and spell your last name for the court?
Officer Jeffrey Davis, D-A-V-I-S.
And sir, how are you currently employed?
I'm employed by the town of Harwich Police Department.
How long have you been employed in that capacity?
19 years.
Prior to joining the Harwich Police, do you have any other law enforcement experience?
No, sir, I do not.
Turning your attention to March 1st of this year, approximately 12:30 a.m., sir, were you on duty that evening?
I was.
And approximately 12:30 in the morning, where were you, sir?
I was dedicated to the west sector of Harwich in a marked unit G14.
Okay, and specifically, where in the west sector of Harwich were you?
I was patrolling on Main Street in that side of town, sir.
Okay, and about 12:30, as I said, officer, anything in particular come to your attention?
I observed a blue sedan driving west on that road with a broken taillight.
Okay, and when you made this observation, sir, where were you?
I was driving my cruiser.
Okay, and were you directly behind this particular sedan as you describe it?
I was.
And if you recall, officer, which tail light was out?
It was the left rear.
Okay. And based on these observations, Officer Davis, what, if anything, did you do?
I activated my blue strobe lights and I stopped the vehicle on that road, and I approached the vehicle.
Had you made any observations of the interior of this vehicle from your vantage point prior to activating your blue lights?
I noticed that there were 4 or 5 people in the vehicle. The people in the back seat were moving around, reaching, ducking, looking back in my direction.
Based on the observations you have told the court that you pulled the car over, what, if anything, did you do next, officer?
Based on the fact that I was a single officer car, I radioed for backup. I exited my vehicle, approached their vehicle, and asked them for their license and registration.
Okay, and when you say you approached the vehicle, did you make observations, further observations of the interior of the car at that point, officer?
Just that there were 5 people inside the vehicle.
Okay, and as you approach, where did you approach? Which side?
I approached from the driver's side.
And did you make any observations of the driver of that vehicle at that point, officer?
I did not.
Okay. And you had mentioned to the court earlier that your intention was to get the license and registration. Did you do that?
I did.
And any issues with that? Was the driver able to produce the registration and the license?
He was.
Okay. And did you make any observations of his person at that point?
No, I did not.
What did you do next, officer?
I returned to my cruiser, ran his information through the computer and was entering it in, at which point I glanced up and I noticed that the people in the vehicle were still moving around.
Okay. And when you say moving around, you previously described to the court ducking and moving side to side. Are those the same observations? When you say moving around, is that what you mean?
They were.
And
Pleading.
I need that piece of evidence. What did you do next, sir?
Backup arrived. We approached the vehicle again. We asked the occupants to exit the vehicle, at which point we searched all the passengers of the vehicle.
Okay. And, sir, in your training experience, what would be the significance of people moving around in the interior of a car?
either to hide something, stuff something under a seat, between a seat.
I object.
Sustained.
And
We'll explain all this in a minute. Matt's taking a little license here. He forgot that he's in court. Go ahead.
what did you do next, sir?
Once we get them out of the vehicle and we searched them, we searched the vehicle, at which point we found an open bottle of vodka.
Okay. And what did you do next as it relates to that bottle of vodka?
We secured it and we searched the rest of the vehicle.
Did you have any conversation with any of the occupants relating to that bottle of vodka?
We did. We asked them if whose it was. No one in the vehicle wanted to take responsibility for it.
Okay. And when you said you had gotten license and registration information from everybody in the car, was anybody in the car 21?
No, sir.
Okay. And what did you do next, officer?
We searched the trunk. We found a quantity of marijuana. We placed everyone under arrest. We transported them back to the station for booking.
Okay. And did you do anything at the scene, officer, as it related to the driver?
As it related to the driver, he was given several field sobriety tests, to which he failed.
Okay. And please describe again, I'm sorry, what you found in the trunk of the car?
We found a quantity of marijuana inside the trunk.
I have nothing further at this point.
All right. Attorney Hawkins, cross-examination.
Thank you, Your Honor. Good morning, officer.
Good morning.
You pulled the car over on Main Street
That's
shortly
correct.
after midnight,
Correct.
and you noticed that there were 5 people in the car, 4 or 5, you said?
That's also correct.
And you noticed that they were young people, right?
At the time, I didn't know whether they were young or not, but yes, as I approached the vehicle, I determined that they were young. Correct.
And when you saw the car, the only thing that stood out to you was that there was a taillight broken.
That's correct.
The car wasn't speeding,
No, sir.
the car wasn't leaving,
No, sir.
wasn't driving inappropriately in any way other than the faulty equipment.
No, sir.
When you activated your blue lights, the car pulled over appropriately, right?
Correct.
Pulled right over to the side of the road,
It did.
stopped in a safe place.
It did.
At that point, you said that you noticed people in the back seat moving
Yes, sir.
and looking back in your
Correct.
direction. And your blue lights were still on at this point, right?
They were.
And the movement that you described earlier is consistent with somebody attempting to put on a seatbelt, isn't it?
I couldn't say so.
It's possible that the movement wouldn't be the same movement involved in putting on a seatbelt, isn't it?
It's possible.
At that point, you called in a backup cruiser,
I did.
and then you approached the car.
Yes, sir.
You had called in a backup cruiser, but you approached the car on your own before backup arrived, right?
I did.
When you got to the car, you asked for the license and registration from the driver.
Yes,
Inside of the car is dark at this point.
it is.
The driver responded appropriately, right?
He did.
You were able to understand everything he said,
Yes.
produced his license,
Yes.
you returned back to your cruiser.
Yes.
The license and registration were both valid, right?
Correct.
While you're in the cruiser, you see some more movement, right?
Correct.
And you go back to the car at that point,
Yes.
correct? And at that point, the interior of the car is still dark, right?
Correct.
The purpose for you pulling over this car was for the broken taillight, right?
Correct.
You'd run the license and registration, and everything was valid, correct?
Correct.
And at that point, you ordered the people out of the car.
As I ordered them out of the car after additional movements were made by the people in the back of the car and after my backup arrived, yes.
Okay. After you ordered the people out of the car, you pat searched everybody?
We did.
No weapons?
No, sir.
Nothing to indicate any danger to you or anybody else at that point?
No, sir.
Would you like me to continue, or?
No, that's good. All right, ADA Kelly, any questions on redirect?
Just briefly, officer, the defense counsel asked you several questions as it relates to your view, your vantage point, how you could see what you could do in the car. Did you use a flashlight on the side of the road during that stop?
I did.
And he also asked you a line of questions, officer, relating to pulling people out of the car and whether you discovered any weapons. Do you recall that particular line of questioning?
I do.
Why did you ask everybody to step out of the car, officer?
For my safety as well as theirs.
Nothing further. Thank you, Your Honor.
One last question, please. Officer, you wrote a report about this incident.
I did.
There's nothing indicating that you were in fear of your safety or others at any point in your report, is there?
Okay, we'll say there is. Okay.
No more questions, thank you.
All right. Do you want me to read this, John?
Why don't you go ahead and leave? I think what we'd like to do is open up for questions from you, not necessarily to step in and grill Officer Davis, though perhaps some of you would enjoy that, but a question you have about this scenario. This is a hypothetical. We did have in our hypothetical, though I guess it didn't come up in the motion to suppress yet, but the idea that the driver was then given a breathalyzer when he came to the station and blew a .03 as a number, and the charges, and I believe, and correct me if these charges would not be the exact same, the passengers were charged with minors in possession, the driver was charged OUI and possession of marijuana with intent to distribute, the quantity in the trunk of the car being found to be more than an ounce. So that's all.
Well, yeah, the only thing I didn't put in that would be relevant to one of the charges was that the driver had $400 in his pocket.
Oh yeah, that was another thing that was found on the pat down.
Is this like a true story?
No, it's a hypothetical.
How'd you guys come up with this?
I'll take credit for it. I mean, it's designed to be a point where it's an issue about whether or not, you know,
Yeah,
the
this sort of
police
thing
were.
happens all the time, I bet.
What's that?
I bet this happens all the time.
Not to me personally, but it is a hypothetical. I can't say distilled from stories coming from students, but no, it's hypothetical. So yes, Judge Rufo, please.
Before we get into a discussion of the law, I just wanted to tell you a couple of things about the procedure that we use in court. One of the courses that we all take in law school is sort of like the rules of engagement for the lawyers to be able to practice in the court. It's called evidence. And it's a very important course because it deals with the length and breadth of what the attorneys can do by way of getting the evidence out. So what you saw by ADA Kelly was a direct examination of Officer Davis, where Officer Davis is testifying, you know, as a so-called fact witness based on what he saw, heard, and felt with his own senses. So the questions are more in an inquisitive tone, but the answer can't be suggested or subsumed in the question. So a couple of times, the reason why I was smiling and looking at Rob Hoffman was, you know, are you going to object to this? Because he was violating the rules of evidence by virtue of asking what's called a leading question. A leading question has in it, if you will, a suggestion of the answer to the witness. It makes it very easy for the police officer or any witness to answer the question, you know, to help feed in to the burden of proof, because he has the burden of showing that this factual scenario doesn't tread on the constitutional rights of the accused. So that's, I just wanted to get that out. Now on cross-examination, you saw a different style, and the rules of evidence suggest this, where the defense attorney can cross-examine by leading questions. So the best question on cross-examination, isn't it true that, and then the rapid fire. You went up to the car before your backup arrived. So that raises the question, well, if the officer was that concerned about his safety, why didn't he wait for backup? Because the car wasn't going anywhere, nothing was going south, if you will. But of course the officers come back and say, well, we're concerned because it's late at night, it's dark, we're out there by ourselves, we have this thing called exigent circumstances, emergency circumstances that we are concerned because, for our safety, because it has been known to have happened, and if there's been tragedies all about this and we don't make light of it, where a routine traffic stop turns into a police officer's worst nightmare because the person in the car has a gun or other weapon that they could use in a retaliatory fashion. So the defense is always looking for what's called the pretext. What's the excuse for this stop in the first place? Well, the officer has a function and an obligation, it's called the community caretaking function, to make sure that we're all operating on the roadway safely. And part of his responsibilities is that if he sees a headlight out or a tail light out, he's supposed to let the driver know that you have a headlight or tail light out so that your safety is not compromised. Nothing worse than a single, I'm sure you're all driving, but you know, you see one headlight coming at you, don't know if it's a motorcycle or a car or which side of the road it's on, especially on some of our dark and dimly lit Cape roads. So there was no pretext here for the stop. In other words, he didn't use the tail light as an excuse, nor did he lie about it. That's the reason why he stopped. But that triggers the discussion, the legal discussion. So why did he stop? He didn't stop as part of what's called a criminal investigation. He stopped as part of the community caretaking function of
a broken taillight. So that puts us into a zone, and right away triggers in my mind cases that I have to know. And there's one case that came down from the Supreme Judicial Court a number of years ago now, and it's called Commonwealth versus Gonzalez. In Commonwealth versus Gonzalez, it's a Supreme Judicial Court case, which is the ruling precedent, the legal authority at this particular time, which suggests that police officers during a routine traffic stop like this cannot order people out of the car unless certain elements are met. And that's part of what we're going to talk about right now. Okay? So, Idea Kelly, you take it away from there. What are you trying to do?
Well, as the judge said, the first, as a prosecutor, my primary concern is to take it one legal step at a time. So the first thing we have to deal with is why was the car pulled over? And like the judge said, that was a pretty clear traffic violation. You can't drive with a taillight. So a broken taillight, and I asked him questions specifically about how far he was behind the car, what time of night it was. That way, you have a picture in your head. It's one car, he's right behind it, there's nothing to interfere with his view, the taillight's broken, that's a good stop. Now, going from there, now we need to figure out, the next thing that I have to deal with is what we would call an exit order. Why would these people, on a broken taillight, ask to step out of the car? Now, that's kind of a reach. It's not like we got a phone call for, fleeing gunshots or, something that would cause what we would traditionally have as like an exigency, like somebody's in real danger. But what the judge alluded to, and what we have to deal with is, and the officers more specifically have to deal with, is officer safety. So if there's 5 people in a car, and there's one officer, and they're moving around like crazy, and the officers can't see their hands, and things are being stuffed under the seat, that's the kind of argument I would need to make to a judge. I need to prove that Officer Davis's safety could be in danger, and he needed to get the situation sort of diffused so he could deal with his safety. And that's the reason why I asked a couple of very leading questions about exactly what he saw, because ultimately this case, at least separating ourselves from the trunk of the car, we'll get to that in a few minutes, the interior of the car, this case is really going to come down to simply what those movements were interpreted as. Because that's really all I have as a prosecutor. There was no threat, nobody in the passenger seat, didn't give his license over, or there was nobody that said, was staring the officer down, there wasn't cell phones ringing, there was nothing to suggest anything was a foul except for the movements. So when I have a case like that, what I need to do is really have the officer describe these movements, because we call them furtive movements in the law. But what does that really mean? I want to know what he saw. I want to know what he saw, where the hands went, where the head went. I mean, it's a big difference if you lean over and put a seatbelt on, which I thought was good cross by Rob. Like that's a solid move by a defense counsel, because obviously everybody puts their seatbelt on and it's not on and they get pulled over by a police officer. So that was a good line of questioning. But what I want to do is say, no. He wasn't putting a seatbelt on. He was underneath the seat. He was stuffing something in the seat in front of him. She was leaning over out of sight. And a lot of times in a real case, you'll have like several times where the driver won't comply with commands. Put your hands on the steering wheel. Put your hands on the steering wheel. Put your hands on the steering wheel. Put your hands on the dash. 4 or 5 of those things coupled with some movements, I'm starting to do a lot better. But so I'm focusing really on this part of the case. You want me to just talk about this part for now?
No, that's good. Just mention the flashlight, and then Rob's going to...
Oh, and obviously the flashlight, that gets into the plain view scenarios, meaning if he doesn't have to ask any of you to step out of the car and just flashes a light, knows everybody's underage, and sees a bottle of vodka, well then, now we've risen to a new level of suspicion. We're beyond suspicion into probable cause that there's some criminal action afoot here. So his vantage point, the flashlight, the illumination of the interior of the car suggests that, yeah, he definitely could see a bottle of vodka. I'm not sure if that was the fact scenario.
But you were trying to get to
I was trying to get to that.
Let's
So,
get a question now.
go ahead.
You said he walked up to the car with his flashlight on, which meant he could probably see somewhat what was going on in the car.
Mhm.
And he didn't pull the kids out until his help arrived, which meant he wasn't by himself. He wasn't in danger quite as much. You said that he might have been looking out for his own safety because he was by himself, but they didn't pull the kids out when he was by himself. He was with another officer.
Right, and certainly, there's a counter argument to that is we're not going to make a police officer on the side of the road take his life into his own hands.
Yeah.
Sure, if originally he walked up and he saw the kids moving all about, it's 5-on-1, it's the middle of the night. So as long as he can step back and see it right in front of him, I'm going to argue to the judge, well, I'm not going to ask Officer Davis to gamble with his life. I'm going to wait till somebody else gets there, and then I'm going to ask him to step out of the car. But that's a good question, because that's an important fact when it comes to things like this.
also the facts did discuss that there were more movements in between. He went up, saw some movements, might have made him suspicious. He goes back to the building, he looks up, and they're moving more. Well, at that point, I mean, they either have their seatbelts on or not. If they're still moving after his first approach to the vehicle, then yeah, potentially it's not about seatbelts. Because if they were there without seatbelts on, he already caught him. He already would have seen that. So that have the additional furtive movements in between before the backup arrives, I think, is also significant.
All right, Attorney Hoffman, what are you trying to get out on cross-examination?
There's a lot of different situations that come up when a car is pulled over. This is a very straightforward situation. If this were a real case in court, there would have been a lot more objections. I think it was important, just to further the discussion, that it be made clear that the officer had at least some safety concerns. Because the idea in a traffic stop is what kind of invasion, if you will, of your rights is allowed under that set of circumstances. Now, the officer was absolutely allowed to pull the car over because of the broken taillight. Absolutely okay approaching the car and asking for a license. The questions start coming into when people are held for longer than the situation warrants. That's when the Constitution starts to become a conversation. If there were no safety concerns, if there was no movement, it would have been, thank you for your license, write the ticket, send you on your way, period. Anything more than that would have been, at least arguably, a violation of the individual's involved rights. But what you have to do when you're defending a case like this, or when you're challenging the actions of the police, is you have to take it step by step by step, because what the court's eventually going to look at is whether the actions of the officer are proportional to the situation as it develops. Whether what an officer asks you to do amounts to an invasion of your rights, or involves, as the judge said, your responsibilities of cooperating as a citizen. Now, once there's an issue of movement, the question then becomes, and it doesn't take much, do the officers legitimately fear for their safety? If so, they can ask everybody to get out of the car. Now, the question of whether they really do fear for their safety is a live question in this conversation, in this scenario, because he did originally approach the car without waiting for backup. But that's something that would be discussed after the officer's done testifying. The attorneys would make their suggestions to the judge about on which side of the law all these actions take place. So the question becomes, okay, was he right to get them out of the car? The next question is, did he really see the vodka before he asked them to get out of the car? And I think that's a question that's up in the air. I think, is it possible to assume that he did? Absolutely. Is it reasonable to assume that he did? Absolutely. Is that really the way that the testimony came in? That's a different question, and that's a question that the judge has to answer. Another thing before I go further than that is that the fear for the safety is, 5 teenagers in a car are bound to be nervous when they're pulled over by the police. So are these movements that they're making, are they really furtive movements? Are they just nervous energy on the behalf of the teenagers? Who knows? But every step of the way, you have to ask the question, is this okay? So, all right, there's a fear for safety, allegedly, so they're out of the car. Next question, what happens here? Is there anything illegal spotted at this point to allow any further search? There's no weapons. Again, the question is there really a fear for safety now after everyone's been pat down, after nobody's found to have a weapon? Why aren't these kids said, get back in the car, here's your ticket, go on your way? If that, at the point that they go to search the car, they find the bottle of vodka, they haven't really come up with a reason for a search yet. If they see the vodka before a search, well then maybe that's reason to search the car, assuming that the officer does know that everybody in the car is under 21, or at least has reason to believe that everyone's under 21, which I think in this case is probably a reasonable thought on the officer's part. But then the question again becomes, and I was asking some questions about the driving of the car, because we have people taken out, we have people searched, then we have a car searched, but then we have field sobriety tests that aren't done until after the vodka's found. That's why I asked the questions of the officer. Well, he pulled it over for a taillight. The car wasn't driving erratically, the car wasn't swerving. Basically, the person didn't appear impaired. So really the question that I'm asking, not necessarily the officer, but the court is, what
Yes.
What evidence is discovered
I have a
here
phone call
without a
from
violation?
Lincoln.
And my point to the court is going to be,
Yes,
there's no evidence that's discovered here that doesn't come about because of a violation of the rights, because of an exceeding act, the officer exceeding the sort of the scope of the situation by asking more of the people involved than they really can constitutionally be asked.
Okay, so here's my job. I'm asked to listen to this type of evidence and then use this case, which is the Gonzalez case that I have in my hands, and look at the holding, which is the law that applies to this type of scenario as closely as I can to try to find sort of an analogous legal underpinning for either side's argument. So after the motion to suppress evidence comes in, the officer steps down, and then the two attorneys argue, respectfully, of course, before the court, but they make their argument based on what they believe is the law. And then I either have to recite my decision or I have to write it out. Most of the time I write it out, type it up, and hand it out at a later date so that the matter is, quote, taken under advisement. You may hear that or you see that in the newspaper. And then within a week or two, or sometimes it takes me up to a month, depending upon how busy I am, I will type up the decision and send it out to the party. So we have an in-court date. And when we have an in-court date, it's kind of fun because ADA Kelly comes bouncing right in on time because he's interested to see what I might have done with respect to this case, and so does an Attorney Hoffman, because I'm a bug about going out at 9 o'clock. And I come out, and bam, the clerk hits him with the decision in writing. So in this particular case, I'm really asked to step into the officer's shoes because I have to find out whether or not in a routine traffic stop, the police officer has, here's the language, an objective, not subjective, not what he's thinking, although I understand what he's thinking. He's thinking fear for my safety, which is what they have every day they're out there protecting us. But I have to decide whether or not there was an objective, reasonable basis to justify the exit order, the order to get out of the car, because that's how he came across the incriminating evidence. Everything else up to that point is pretty good, but the incriminating evidence, which may or may not justify him getting into the trunk, we're going to get to that in a minute, was the so-called bottle of vodka. I didn't hear during the testimony exactly where that bottle of vodka was, and it might have been that part of the furtive gestures were that the kids were kicking the bottle under the front seat. So you may have found it not in plain view. Matt wants to suggest that the officer, which they can by a number of cases, shine the flashlight in, because anything you can see within your vantage point falls under an exception to the Fourth Amendment, and we call it the plain view doctrine, meaning that they can seize evidence that they can see if in fact it is evidence of a crime. So the classic is the ashtray that has the roach clip in it, the burnt marijuana, all of that. If it's out in plain view, it's open season. They can seize it. They don't need any more than that, and that gives them sufficient probable cause. So in this case, we're talking about, was there an objective basis for the officer to order, if you will, the occupants and the driver out of the car? And the underpinning of this is that the Supreme Court said that motorists have a reasonable expectation that the police will conduct a routine traffic stop quickly and with minimal intrusion. There's the High Wire Act. There's where the officers have to decide, am I treading on someone's rights, or am I treading on, or am I encountering a situation where I have a reasonable suspicion? It's called reasonable inarticulable suspicion that there might be some criminal activity afoot. That gives him the level of intrusion that's necessary for him to extend, his training, his expertise into the situation and decide whether or not there might be something not quite proper going on here. So, as Rob said, the statement of the law is that the officer's intrusions must be proportional to the suspicion that prompted the intrusion. This is all law stuff that I have to look at and say, in this case, was the police officer acting proportional to the suspicion that he had, which prompted the intrusion, i.e. the search of the vehicle after the exit order. So there's multiple layers of Fourth Amendment going on here with respect to the facts that we just quickly brought out. Now, what do you say about the trunk? How's he get into the trunk?
Well, the part of the scenario we didn't get into because we were running short on time
Here comes the makeup now.
Go ahead. Is that he continued to search the car in the trunk. If this was an actual motion to suppress, I would have asked a lot of other questions as it related to could anybody drive the car, where was the car on the side of the road, And if the car is on the side of the road, obviously we just don't leave cars on the side of the road. Did you search pursuant to an inventory policy? That's what I would have gone with in this case. But in these particular facts, what I would want to know.
Inventory policy.
Well, I got to get in the trunk somehow. But in this case, I would have asked the officer. My argument would be to the court ultimately probably that since they discovered a bottle of vodka, it was reasonable to believe that there were more illegal things in that car, and that's how I would try to justify that particular search.
Okay, so by what we discuss, usually if there's probable cause, which the bottle produces, that they could search the trunk as part of a search based on that probable cause.
But that would be.
Well, I'd like to hear Attorney Hoffman's argument.
Yeah, that would be my argument.
How do they get into the trunk before they even towed it to the tow lot and show the inventory policy and all that? How does it get in the trunk?
Well, my answer is he doesn't. There's no way that it should have got that far. Sometimes you have to go all the way back, assuming that the judge is going to say, all right, he saw that bottle of vodka, that's illegal, he can arrest these young people in the car. Well, maybe they get into the car now because they can search more fully when they've got a legal arrest. But realistically, I don't think that that bottle of vodka is going to give the officers any right to search that car any further, because that bottle of vodka is evidence of the crime of minors in possession of alcohol. But in order to search further, the police have to have a reason to believe that they're going to find more evidence of that crime, minor in possession of alcohol. I don't think in a case like this, there's any reason to believe that there's any evidence in that car further than that bottle of vodka that they already have that would lead the officers to further criminal behavior. So my position would be that, no, there isn't probable cause to go any further. You've got your bottle of vodka, it is contraband, you take it away, and that's the end of the story.
Well, let me bring Officer Davis, I'll put him on the spot on this. Okay, you're out in the street, you found the vodka, you got your flashlight, that's how you found it. You got the kids out, you have your backup, they're all in handcuffs, they're sitting on the curb. What do? You're going to go right into the trunk and look for more evidence of criminal activity?
We would search the interior of the vehicle per our inventory policy. And then, yeah, we would, per our inventory policy, we would go into the trunk.
Right on the scene?
Right on the scene.
Okay. All right, questions?
Would the $400 found in his pocket be
Yeah, the police-
reason to search further?
You can only inventory a person's contents if they're already under arrest. So this brings up this whole Terry stop. Have you heard of the case, Terry versus Ohio?
Yeah, at least some of you have heard of it.
Okay, and this is a case involving.
He said at least some of them.
Well, no, I don't know if, I only said because I'm not sure Ms. Kios's class is
Talked
covered.
about it yesterday.
You did it yesterday, okay.
Yeah,
So
we
you
did.
There's a
Oh,
United
so then
States,
you all have heard.
yeah, there's a United States Supreme Court case that talks about police officers.
Please.
If not,
Yeah,
Please.
police officers need more than a hunch. They can't just walk up to you and start patting you down. They have to have reasonable articulable suspicion that there might be something afoot. But they have to have certain threshold understanding with respect to how far they can go. But in this case, if someone's arrested, then the police can empty their pockets to make sure that they don't have criminal evidence, what's the word I'm looking for? Evidence of crime on their person. So that's how the $400 was discovered. Of course, the $400 is going to go to Matt. He's salivating about the $400. Why? Because that can be put in front of a jury that there might have been some selling of marijuana, and those were the proceeds from the sale of the marijuana that they found in the trunk. Possession with intent to distribute. So he wants the money.
I'd lay it out bill by bill right in front of the jury and say, how many 18-year-olds you know have this in their pocket? And let you draw your own conclusions.
Other questions? Yeah.
What about?
Sorry.
I was going to ask about, students are always asking, well, can they search the locked parts
Yeah,
of your
lock.
car? Can they search your trunk?
Once they have you under
Or your
arrest,
glove
yes,
box.
they can comb it. And once they have you under arrest, the law recognizes police officers' right to do an inventory search. Of course, it's not to look for incriminating evidence, that's what I was trying to get. It's not to look for incriminating, it's to protect you, to make sure that you don't have any valuables, rings, jewelry, iPod, iPhone, iPad, in the car that could possibly be stolen at the dreaded tow lot. So they do this for your safety, right, Officer Davis?
That's correct.
Yes, they're doing it for the safety of the persons. You can tell by my facetious tone that this is gold. This is what the police officers live for. They want to be able to look in the car after they pull someone over and have someone under arrest because they can do so under their inventory policy for your safety. Yes, sir.
You said that they have right to do this after the person's arrested.
Yeah.
What if they somehow they come up with a reason to search this car, smell, anything like that? They search the car, they don't find anything.
Yeah.
There's a locked compartment or a couple locked compartments. What can they do
You've
there?
asked a bunch of questions. There's a famous case called Commonwealth versus Kitchings, and it stands for this proposition. If you are dumb enough to smoke marijuana in the car, and your police officer walks up to the window, and you roll down the window, or it's summertime, or you have AC, and you're smoking marijuana in the car, and they roll down the window, they can smell marijuana. They smell it, they got you, because now they can go in and look, because the aroma of marijuana in that particular case was enough for the police to justify a certain level of intrusion to get into the car. So I've seen many a motion to suppress come before me under this case, Commonwealth versus Kitchens, without the smell of marijuana. So a search incident to a lawful arrest, that's what we're talking about. Search incident to a lawful arrest. A search following a lawful arrest gives the police officers that right to look into those compartments.
So if they smell anything, they search the whole car.
Yeah.
They don't find anything, they can still go into locked compartments.
Well, they're still in the midst of doing their inventory search. So, of course, if your glove compartment's locked, okay, this case is about this. If your glove compartment's locked, they may have concern because in the glove compartment, you probably left, Aunt Bessie's jewelry in there that's worth thousands and thousands of dollars. But really what's in there is God forbid, the gun or the marijuana or something like that. That's what they're looking for.
Wait, but can they tow your car if they smell marijuana but
Sure.
don't find
They can
anything?
arrest you on scene. You're now, plus this case, the driver was impaired, so the officer can't allow the driver to drive the car. And so they take the person into custody and then they call, what do we call for our tow in Harwich?
Depends on who's on duty, handlers.
Okay, they call handlers, which is right there on Route 28, right? Anybody know what George's Fish Market is, right beside it? Yeah. Just want to test your knowledge of Harwich. Are you people from Harwich?
Yeah.
Good, I just want to make sure. Okay, who had a question over here?
Let me back up 1 second, and then we'll get to you. When you roll down the window, then he rolls down the window, and you smell either alcohol or marijuana. That the aroma itself is not. Is that going to lead to an arrest, or is that going to lead to probable cause to search?
No, it's not illegal.
It could lead to both.
But just on the
More in the
marijuana.
sense of the aroma of the marijuana, that's probably more apt to lead to an arrest. The aroma of the alcohol could lead to.
Here's your legal authority, right here.
Feels
To your
right.
question though, I think what was confusing, so say they walk up to your car and they smell an overwhelming sense, like odor of marijuana.
Yeah.
Search the car, they don't find anything, they're not gonna arrest you for anything.
Yeah.
There has to be an arrestable offense before they start searching your car.
Yeah, if you just smoke.
I mean, I'm sorry, before they start, inventorying your car.
Please listen.
So if they walk up to your car, somebody's car, and it smells like marijuana, all right, they can search in that car anywhere where marijuana could be kept. That's Commonwealth versus Kitchens. That answers your question about lock boxes or trunks. But if they don't find anything, and the driver's not under the influence of alcohol, you're going to be on your way.
Or drugs.
Or drugs, right? Or drugs. Then there's no other reason to keep your car any longer, or you any longer. So
That's a search based on probable cause, not just from the arrest. The odor of marijuana, please listen. The odor of marijuana or alcohol is going to give probable cause that there's going to be evidence of illegal activity, and then under the motor vehicle exception, to allow to search the car thoroughly, including the trunk or the glove compartment or locked containers. But as Attorney Kelly said, if they don't find anything, then there's no evidence to take to trial to try and prove you're in
There's nothing to arrest
possession.
you for.
Nothing to arrest you for.
This gentleman
Jen.
had a question.
You guys said this isn't. I was just kind of asking how you tell, but you said if they're not under the influence of alcohol or drugs.
Yeah.
Alcohol you can do a breathalyzer. Drugs, how do you figure out?
Oh, they have a field sobriety test for drugs too. If they think that you're impaired
Yeah.
in any way, shape, or form, then
Listen.
you're gonna wind up in the back seat of the cruiser. And you're under the arrest for operating. It's a tougher case for the DAs, for sure, to prove operating operating while being under the influence of drugs, impaired by drugs. It's a much tougher case because the police officers, they memorize this their first week of police training. Slurred speech, bloodshot eyes, you know, aroma of alcohol on the breath of the person who was talking to me. It's not like the commercial you see. It's a horrible commercial where the guy rolls the window down on a gal and all the alcohol comes spilling out. You saw that commercial.
Yeah.
I play it all the time. It's a little bit.
I don't get cases like that.
All right.
No, on the possession of marijuana, it is harder. There's no breathalyzer for marijuana to blow. Now, there is a case I used an example from about 10 years ago of a fatal accident in, I think it was Plymouth, that led to a charge. And because it was a fatal accident, they got a blood test. They got a warrant for a blood test. They used a blood test, could establish the THC level to prove they were under the influence of marijuana. And Matt, under what circumstances might they get that warrant to do a blood test for marijuana?
Well, they're hard to get. Blood warrants aren't the same as regular warrants because we would actually need to find a judge to get that warrant. But what happened?
Harwich.
What we do? We had a couple in Harwich actually. But the scenario where we most often get blood evidence on an operating under the influence case, whether it be drugs or alcohol, if there's a motor vehicle accident, if there's a crash, and as a result of that crash, you, the driver, had to go to the hospital. If you go to the hospital, they're going to take your blood under those circumstances for anything, just to make sure that they're covered at the hospital. And I'm going to know that you went to the hospital as the DA, and I'm going to subpoena your hospital records, and then I'm going to know what was in your blood. And that doesn't have anything to do with it.
Yeah. And at the same time, the defense attorney is entitled to the results because they have open season discovery. Anything he knows about the case, he has to share with the defense. We have reciprocal discovery rules. So the defense, Attorney Hoffman, is salivating because he wants that hospital record because it could be exculpatory evidence. What's exculpatory evidence?
Anything tending to show you're innocent.
So
And I have to turn that over.
He's going to use that on cross-examination, you know, of one of the DA's witnesses. Impairment? Look at this blood alcohol record. It's below the legal limit. And of course, then they're going to get the chemist in to describe how long these substances stay in your body, in your bloodstream. Question.
Okay, well, the weed stays in your system for a long time, right?
What does?
Like marijuana.
I don't know.
It's, and then, but like if
You
they
let me
do
get
a
away
blood
with it.
test,
What's that?
if they do a blood test, they, like for a warrant or whatever,
Yeah,
but they weren't driving under the influence, but smoked like before.
I know. In this age of CSI, we call it the CSI effect. We're not able to turn information around. And on CSI, it's a 1-hour show with commercials. I don't even watch it, but I hear that in CSI, the crime happens, they investigate it, they get all the evidence, they get all the lab results, and they find the guy guilty all in 60 minutes. It doesn't happen that way.
Yeah.
But
And if I was prosecuting the scenario that you're talking about, there's going to be more because you're going to have been arrested already before they get your blood. So yeah, you're right. My understanding is marijuana stays in the system obviously for 30 days, whatever, 26 days, whatever it is. So if but I'm also going to present evidence that you couldn't open your eyes, you were slurring your speech, you couldn't pay attention, and then after that, I'm going to put a doctor on the stand and said, oh, by the way, what was in her system? Marijuana. Now you've got a tougher case. Now what Rob would do is say, well, he'd argue what you're saying. That's not evidence of that night. It could be evidence of any night. But it's going to be the combination of all the evidence that I'm going to be able to, based on the observations of the person and their blood, you, the jury, I'm telling you that they were under the influence of marijuana that night.
at trial, by the way, the Commonwealth has to prove the elements of the offense beyond a reasonable doubt. Very high standard of proof. So it's not ivory soap, 99 and 44, 100%, but it's pretty close. And so we talk about these standards of proof that the Commonwealth has to meet in order to have a conviction returned by the jury unanimously. Question?
It's just kind of like a random question, but
We take random questions.
alright, cool. Alright, say like one night everyone's bored and this one kid just decides, you
There's
know,
nothing boring about
I'm gonna have
Harwich.
some friends over, right?
Yeah?
His dad is home, he just decides to have friends over. And everyone's downstairs
Our
having a
parents
good
home?
time, dancing,
Our
listening
parents
to
home?
music. Yeah,
Yeah.
there's no alcohol.
Dad's home, dad's
Are the
home.
Parents are home, yes.
Okay.
Yeah.
Alright, so the police come to the house and they're like, oh, you know, no noise complaints, but These are young kids. We assume there's alcohol. Knock on the door and say, party's over. What gives
This
them the
wouldn't be
right
like
to
2 or
make
3
the
nights
kids
ago,
leave?
would it?
No, of course not.
No, of course not.
I'm
No.
just asking, what gives the police the right to stand in his front yard and say, party's over, and like flashlights?
Let me, like briefly, the scenario you're talking about is actually the second scenario we're gonna do C block, which is gonna be a party scenario.
You can come back and watch that.
You can come back, or like I said, if we post all these on YouTube, you can watch it there. Briefly, and let me give you one quick answer, and then I'm sure they can give me a better answer. There's nothing to stop the police from going up and knocking on your door and,
I know,
and
no, I'm
having a
saying,
conversation with people.
Why can they say, party's over, and tell everyone to leave?
I think in the interest of trying to protect the safety of people, they could maybe make such a statement.
What if they're just hanging
Why
out
do they
listening to music?
Like,
Well,
we were just sitting listening to music. Like,
They're
yeah.
I don't want to, please. I don't want to get too involved in that scenario because I want to. We have about 4 minutes to give the conclusion of this scenario. So tell you what, why don't we pick up that scenario in the discussion in class tomorrow, and particularly after we'll have seen the discussion of the later scenario.
Thanks for preparing us for C block, though. It
Yeah.
sounds like they're gonna have some questions.
All right, any other questions?
Alright.
All right. All right. We'll allow the judge to render his decision.
Well, in this case, I think that I have to say that the routine